Before we discuss the history of your formation of the law firm of Howland Fisher, let's fill in a few gaps of your relationship with Governor Clement. During your work with him, particularly when you were working in the governor's office, I understand one of your responsibilities was to not only write speeches for him, but to coordinate the activities of a team of speechwriters. Tell us about that.
Well, he had been disappointed sometimes in the tardiness of some of his speechwriters in getting their speeches to him on time. And there had been a few times when his speechwriters just hadn't got the speeches done in time for him to deliver them. Governor Clement was a great extemporaneous speaker, but he also wanted the comfort, most of the time that he made speeches, of having a text in front of him. Sometimes when he had the text, he would ignore it altogether, and the speech would go for naught. But sometimes he would read the text faithfully. He had a typewriter that had extra large type, and he'd have the speeches typed up in a notebook form, and he got to be expert at flipping the pages almost and following the text almost unnoticeably. But he wanted those speeches on his desk, and sometimes they weren't there. He had several speechwriters. I was not the most prolific, or one of the most prolific of the speechwriters. Two principal speechwriters were Joe W. Henry, Jr., who at that time was the Adjutant General of the state of Tennessee.
And later became Chief Justice of the Tennessee Supreme Court.
Chief Justice of the Tennessee Supreme Court. And the other principal speechwriter was G. Hilton Butler, who in his career in state government had innumerable jobs and had been essentially a speechwriter for a long time. He had been Commissioner of Revenue, Commissioner of the Department of Safety more than once. He had been Director of the Selective Service Commission during World War II. He was just a man of many talents and parts, and he was a principal speechwriter. Others were Brainerd Cheney, who was a would-be novelist, actually got some novels published, and Roque Fajardo, Howard Anderson, and myself.
And you were responsible for coordinating these gentlemen, and you were significantly their junior.
That's right. The governor just made me his bird dog to try to keep after the other speechwriters to get their work done on time, although I was the junior of all of them. And it was my responsibility to bug them if they hadn't gotten the speech done on time.
I understand you bugged Joe Henry one time, and he had a rather significant retort.
Joe Henry, although he was a great phrase maker, he was very erratic in when he would work and get things done. And I knew to start showing up down the hall at his office if the speech was getting close to the time for it to be delivered. So one day I went into his office and he had an assistant, the ghostwriter's ghostwriter. And I knew this fellow, and I saw him working on his typewriter. And I was there to ask about Joe Henry's speech. Well, he was working on it. And I had seen that, I kind of looked over, I'd seen that speech before. What he was doing, he took an old speech and he was putting a new paragraph on the top, and I supposed that Joe Henry had said to him, polish up this old speech for me, and I thought that was unworthy. And I wrote a sort of cryptic note to General Henry. And I mentioned what I had found his assistant doing. I've forgotten what else I said. But I do remember his response. Joe Henry was a great student of Shakespeare and the Bible. So I promptly get a note from him with a quotation from Shakespeare's play Julius Caesar. In the name of all the gods that are, upon what meat doth this our Caesar feed, that he is grown so great? Well, I thought that was very eloquent. I've forgotten exactly. I wrote him another note congratulating him on his note to me. But I think I said something like, I wish you'd put that much effort into the speech.
But you and General Henry, later Judge Henry, had a wonderful and good relationship in spite of that minor rift.
Well, for a while he was so peeved with me that he told somebody at the Air National Guard, which he controlled, don't let Fisher ride on any of the planes. But we later made up. And he very kindly, when he announced his campaign to run for the Supreme Court, he was not appointed to the Supreme Court. He was elected. And when he decided to run for the Supreme Court, I was very honored that he invited me to come down there and sit with him when he made his announcement. At the hotel across from where the federal courthouse is on Broad, is where he had his announcement party. And then he later, as president of the Tennessee, when he was president of the Tennessee Bar Association, he appointed me to a committee chairmanship. And we became friendly again.
Governor Clement had one of the few honors of any Tennessean, and that was to give the keynote address at the National Democratic Convention in 1956 in Chicago. Now, I understand you didn't write the speech, but that you participated in a substantial editing of it. Please tell us about that.
Well, Governor Clement at the 56th convention had some hopes of a nomination as vice president. And some of us had gone to Chicago with him and actually had a truckload of signs, placards to spring to life from the floor of the convention if things went just right. But the speech had been prepared. We could not, I could not, get his attention to do a dry run of the speech for a long time after we got to Chicago. I've forgotten how early we went up, but it was well ahead of the time for his speech. It was maybe as much as a week ahead. And I kept bugging him about the need to run through the speech. Well, he wasn't used to doing that. You know, he felt perfectly comfortable making a speech just right off the top of his head. And he wanted to spend, and was spending, all of his time essentially campaigning. But either the night before the speech or the night before that, and I'm not clear on which, we finally got him to take the text of the speech and do a dry run to see how long it would take, and just, you know, to get him familiar with it. Well, the speech was far, far too long. And he realized it after we timed it. I've forgotten how long it ran. So he handed it to me and said, cut 45 minutes out of it. And this was at night.
The night before the speech?
Either the night or the night before. Either the night before the speech or the night before that. And I'm fuzzy on which. But I remember I sat up a good part of the night cutting out 45 minutes of the speech, and it wasn't as simple as it sounds, because there was a teleprompter with the text of the speech, and the teleprompter had to be redone. But I cut 45 minutes out of the speech. And he gave the speech as reduced by 45 minutes, and it was still a long speech. But at the end of the text, he couldn't stop. He went on impromptu for a long time after he had finished the text of the speech. And he joked about it later. Part of the speech was a phrase that had been taken from Cicero, "How long, oh, how long?" And he had used that phrase several times repetitively in his speech, and afterwards he would say, you know, I know how long it was. And I said, how long, oh, how long, but it was a hell of a lot longer than it should have been. And that was his take on his own speech.
You have a significant pedigree of an orator and a debater and extemporaneous speaker with the regional and almost national debate and speaking awards. Governor Clement was considered to be one of the greatest speakers. How would you critique his speaking, and what made him so good?
Well, first, I would have to say that he was the most remarkably versatile speaker that I can think of. He could make a stump speech at the county courthouse square that I've never seen equaled by anyone. The crowd would have been assembled by the musicians, and he could, boy, he could stir that crowd up. He was like an old-time Baptist preacher who could really, he was passionate. But that was his stump speaking style. And people who can do that sort of thing often can't do anything else. But the next day, he could be on a television interview, and you'd think he was a college professor talking in a very relaxed, intelligent, erudite way. He could adapt his style to the occasion. The most effective speech I ever heard him make was to a very small group of his speakers and floor leaders. Governor Clement was advocating an increase in the sales tax, and it was a very hot issue. he was very determined to get the increase, although he knew it was costing him dearly politically. And some of his speakers and floor leaders at the time were sort of on the fence, and there was talk among them that they might have to back off of their support of the sales tax. And Governor Clement got wind of this and summoned them all out to the governor's residence one night about midnight. And one of the things that I remember he said to them, "I release every one of you from any personal I release every one of you from any personal obligation to me."
And he's speaking to the legislators at this time?
To the leaders and speakers and floor leaders. And then he proceeded to tell them in very passionate terms about the need for the increase in the sales tax and to challenge their sense of public duty. He turned them around.
You remained a dear and loyal friend of Governor Clement long after he left office and until his death in 1969, and then thereafter you and some others from across the state founded the Frank G. Clement Foundation, of which you were one of the leading forces in drafting the charter and bylaws, and then subsequently became chairman and president of the foundation. With that, do you believe that the relationship with the governor's office and that governor helped open some doors for your legal career as it evolved?
There is no question at all about that. When Governor Clement went back into office, for his third term, the interstate highway program was just getting up steam. And land had to be acquired for the right-of-way for the interstate. The Attorney General's office hired lawyers throughout the state in the counties where the interstate was to run to condemn the land that was necessary for the right-of-way. And if they could not negotiate a price with the owner of the land that was needed, then the land would have to be condemned and a jury would have to fix the price. There were many, many owners that they could not negotiate a satisfactory price with. And those cases would have to be tried. The lawyers to try those cases were chosen by the state attorney general and the governor and the Speaker of the Senate, as I remember. I had become a very good friend of the Attorney General, George McCandless, through working with him for those 4 years, working with him, and of course with the governor. And the three of them chose me to handle a lot of those condemnation cases for the interstate highway system. Over a period of about 10 years, into the early 1970s, our law firm handled about 600 of those cases. We probably tried a third of them. And that was a very helpful way in getting me started as a civil trial lawyer. General McCandless also sent to me 141 habeas corpus cases to defend. Habeas corpus, as I'm sure you know, is an ancient writ by which a prisoner can ask a court to determine under what authority he is being held prisoner. And a lot of the prisoners out at the state penitentiary on Centennial Boulevard then were doing handwritten writs of habeas corpus, complaining about some element in their trial, complaining about the district attorney, complaining about their own lawyer, complaining that they'd been unjustly sentenced. And each one of those cases had to be disposed of. There was a writ writer in the prison whose name was Willie Joe Johnson, a prisoner who wrote those things for $1 a page. So if a prisoner had $6, he'd have a 6-page petition for writ of habeas corpus. If he had $10, he'd have a 10-page writ. And I had to defend them. Those would be tried before a judge, of course, without a jury. I would write to the judge and the lawyers, the district attorney, and get them to give what would be their testimony in letter form and ask that it offer it in evidence. Probably, if there was a lawyer representing the prisoner, which sometimes was the case, I'd get him to stipulate that testimony, and he was usually willing to do that. But of those 141 cases, I do recall that I found 4 of them where I thought the prisoner's complaints were justified and arranged to have appropriate relief.
Your relationship with Attorney General George McCandless was also a good and strong relationship. As a matter of fact, I understand that when he decided to run for the Tennessee Supreme Court, he asked you to be his statewide treasurer.
I was treasurer for his campaign.
How did a statewide campaign for the Supreme Court work?
Well, it was very low-key. General McCandless did not get out and make any stump speeches, as you might imagine. A lot of it was telephoning around to political contacts in the counties, people who might have been chairman of someone's political committee, people who were prominent in politics. And a lot of it was just phone work, asking people who might be able to help spread the word in their counties to do that. And some of it was paid advertising. We took out some newspaper ads, and I would also solicit endorsements. Solicited a lot of endorsements from Nashville lawyers and ran their names in the paper.
You were very prominent in the election of George McCandless to the Supreme Court, and Joe Henry asked you to be present when he announced his candidacy for election to the Supreme Court. For the last 20-plus years, the Supreme Court appointments are determined through the Tennessee Plan, which is not an election process. What is your opinion of the former system and the present system?
I think it is absurd for an appellate judge to have to run for office. The scandalous behavior of lawyers and appellate judges in states like Texas in those elections, I fault both of them. Lawyers will contribute large amounts of money to the campaigns in, say, Texas, of the members of the highest appellate court. And I remember reading that in the great lawsuit against Texaco, in which a Texas lawyer named Joe Jamail got a multi-billion-dollar judgment against Texaco in favor of maybe Occidental Petroleum or somebody, some other outfit. The lawyers on both sides of that case had contributed staggering amounts of money to the very judges who were deciding that case. And a system like that is bound to shake the confidence of the public or of any knowledgeable person in the court system itself. Lay people do not know who will make a good appellate judge. Lawyers know, and governors know. And the idea of an appellate judge having to solicit money from lawyers, who are the only people who are going to contribute to it, in order to keep his job is absurd. I think it's scandalous.
How do you contrast that with the election of trial judges as distinguished from appellate judges?
I would like to see the trial judges appointed. I know it's not likely to happen politically, but I don't want to say trial judges are unimportant. They are probably the most important judges there are in one respect. But people in a county where there is a trial judge, say in my county, Williamson County where I live, the people kind of know the candidates for trial judge in their local community. They can learn about them. And it's not as dangerous a system as would be the election of appellate judges.
Let's return to the 1960s. Your relationship with Val Sanford has discontinued. He's gone with B.B. Gullett to form the firm that becomes Gullett, Sanford, Robinson, and Martin. You practice as a solo practitioner for a while, but then you decide you want to do something different. What do you do?
Well, I was getting a lot of work. The other thing was I had a larger office than I needed in the old Third National Bank building. I had a friend, Morton Howell, and what had happened to me happened to him. Some of his, he had two other good lawyers practicing with him in another building, and one of them, Charlie Neese, went off to accept an appointment to the federal bench, and the other, Jim Tuck, took a job with the National Life and Accident Insurance Company, as it was known at the time, and there was Morton Howell left a solo and more space than he needed, and I was a solo and more space than I needed. A mutual friend of ours, Alf Adams, said to me, "Why don't you ask Morton Howell to come over and join you, and you can share, you can split the rent." And that actually was the motivation for my association with Morton Howell. I said, "Come over here and pay half the rent, and you can cut your own rent." And we practiced for a while as associates, and very soon formed a partnership for law practice, and he was my partner for well over 30 years until he died. About that time, I was getting what turned out to be a flood of work. There were the eminent domain or condemnation cases, and there were the habeas corpus cases, and I was beginning to get work from insurance companies. So I had to recruit some help. My first recruit was Steve North. Steve North had been working for me in the summertime while he attended Vanderbilt Law School. And the reason he was working for me was that Governor Clement called me up one day and said, the son of Preacher Ira North out at the Madison Church of Christ needs a summer job. Will you hire him? I hired him sight unseen. And he came to work for me and worked during the summer while he was in law school. And so I got him fresh out of law school. And then I recruited another young lawyer, Jonathan Harwell. Jonathan was working at that time for Charlie Trebue's firm. And so he came over and joined me. And the four of us practiced together for a while, and Jonathan and Steve helped me greatly with my caseload, and were both valuable partners for a long time. Steve later ran for circuit judge and won the election. After 12 or 15 years, Jonathan formed his own law firm. He was particularly keen on a business, corporate type practice. And I wanted no part of that. I wanted to limit our work to trial work, essentially.
Some people who know you think of you as a very conservative individual, which is probably true in some respects, but you're also a pioneer in the legal industry in two perspectives. One, you are considered the pioneer of billable hours in Tennessee, and the other is you convinced some other lawyers to buy real estate and build an entire building, a 6-story building. Tell us about that.
Well, I'll start with the billable hours. Some insurance companies that I started representing came to me, I was quite aware, because they were not happy with the bills they were getting from other lawyers who were representing them. The custom of lawyers representing insurance companies at that time very largely was at the end of the case, so they'd just pick up the file and kind of see how heavy it was and send a bill for services rendered, $7,500 or $200 or whatever they thought their services were worth. That, to me, seemed, I won't say outrageous, but it seemed to me to be inappropriate. If you place yourself in the place of the client, and particularly a corporate client, whoever's dealing with you and the person to whom you're sending those bills needs two things. He needs transparency, predictability, a way to measure your services to see whether he agrees that you are doing a good job for the money, a way to compare you with other lawyers. lawyers at the time liked to say, and I guess some of them still do, well, I can't tell until the end of the case how much I've been worth to you. And there's some justice in that. The rules now for a proper lawyer bill include your value to the client on that particular piece of business. But the client, handling a lot of corporate work, needs to have a budget. And he doesn't need to wait till the end of the case to find out what it's going to cost him, because some of these cases go on for years, and he needs to be able to report to his superiors, here's how much we're going to need to budget on our book of cases, and here's where we are, and here's how much we've paid, and here's how much we've got to go. That predictability of the amount of a lawyer's bill is also vital in determining whether to settle a case. Under the old system, for services rendered such and such an amount, in the end, the lawyer has the final say. And the client can either pay or have a dispute with the lawyer. But if the client is being billed at regular intervals, say once every 3 months, which is my practice, or at monthly, which is some other lawyers' practices, at every stage of the lawsuit, he knows how much he's paid. If the bill that he gets shows every single task that you have performed for him and how long you spent on that task and at what amount, he can look at your bill and he can tell a lot about whether he's getting value for his money. A typical thing on those bills, lawyers often charge for indexing depositions. Well, I know lawyers who will spend 2 minutes a page indexing a deposition, and some of them spend half a minute. And a volume litigator can look at those bills from those different lawyers. He can say, gosh, I'm paying this guy 4 times as much as X. And he can make a judgment as to whether he wants to keep him. And he can also predict with regular billing and with regular amounts agreed to on the front end what his expenses are going to be. And the current rules, current disciplinary rules, have gotten to the point that they ought to be, that the disciplinary rules require that a lawyer representing a new client on the front end have an express understanding with that client on the basis on which he will be billed, and as the rules says, preferably in writing, which has been needed all of this time.
Before I ask you about putting the lawyer's building together, tell us how you decided to focus on the law practice and reduce your activity in government and politics.
Well, I never considered myself to be a politician. I worked, of course, for Governor Clement, who was a politician. But I considered myself simply to be a staff helper to the governor, which I was, and knew at the time I was working for him that at the conclusion of that time I very much wanted to go into law practice, and I very much wanted to do trial work. In order to do the trial work, of course, you've got to have somebody who'll hire you to do it. And that was the reason I was not doing trial work right off the bat when I got out of school. You have to kind of work your way around and get somebody to send you some work. And I was lucky to get a great volume of work from some insurance companies, which started in the early 1960s and has continued to this day.
Your new firm of Howland Fisher was witnessing great success, and you were adding lawyers. At that time, most lawyers in law firms historically rented from some landlord. You had another idea. Tell us about that.
Most of the law firms, nearly everybody that I knew, was in one of the big buildings on Union Street or in the Third National Bank building, in the American Trust building, Nashville Bank and Trust, Stallman building. At that time, the James Robertson Parkway remodeling project, which cleared out all of the land in back of the Capitol building in a great circle, had just gotten underway. And there was a piece of land right across from the courthouse, catty-cornered from the courthouse, at 3rd and James Robertson Parkway, that was owned by the Nashville Housing Authority, and it was available for development. I thought, I'm going to be spending, as far as I can tell, the rest of my adult work life practicing law, and here is a spot that is right next to the courthouse. I would be paying rent over 30 or 40, and as it has turned out, 50+ years of practice to some landlord. Why in the world would I want to do that? You know, it's like buying a house. Why would you want to rent a house for all of your life? It seemed absurd to me to pay rent. So I recruited a number of mostly young lawyers about my vintage, 1 or 2 older ones, and formed a proposal to build a building on that spot, to buy the land from the Public Housing Authority and to build the building. And I got 21 of them together. We also got the First American National Bank, as it was known at that time, to take a long-term lease on the first floor. And we bought the land and built our own building, rented to ourselves at a modest rent, paid for the building long ago. And it's just been a wonderful thing. We wound up with all the landlord's profit in our own pockets. Over the years, the other lawyers all moved out and left me to turn out the lights, so to speak. They're the stockholders. We bought them out as they moved out. The corporation bought them out, and I now have sold that building to 4 of my younger partners, who I hope can repeat the same thing and have the same good experience.
It's almost unfair to ask a lawyer who's practiced some 57 years to identify some of the more significant cases in which he's been involved, but I'm going to ask you to do that in a brief period of time.
Most of the work for which I am generally known, I think, has been the defense of civil lawsuits because of my work for insurance companies. The most interesting cases I have had, I believe, are cases in which I've represented plaintiffs. Defending cases, if you win, nothing has changed. They don't get any money. You don't get any headlines. Nobody's interested in the status quo. And my job as a defense lawyer is to preserve the status quo. So, although some of those cases might be intensely interesting to the people I was defending, they're not of great interest to anybody else. I can think of several plaintiffs' cases that were of great interest to me and to other people as well. Probably the most significant plaintiff's case in which I have been involved was a case for the Southern Railway System. The Southern Railway System was being assessed for real estate taxes for its right-of-way in the counties through which it ran. The assessment of the value of its right-of-way was being determined by the Public Service Commission, but the assessment of other commercial properties in those counties was being determined by local tax assessors, with the result the Southern assessments were at 100% of the value of their land as fixed by the Public Service Commission, and the assessments of commercial properties in the counties through which they ran were about 10% of value. They were paying 10 times the taxes of other commercial property owners. So I represented the Southern in a lawsuit to correct that imbalance. Without going into the details, the Chancellor found that the imbalance justified legal relief, and as a result, every piece of commercial property in the state of Tennessee had to be reassessed so that the values of those properties would be on a consistent basis. At that time, the Constitution of Tennessee said they should be on I think it said on an equal basis. Constitution had to be amended. And now the Constitution provides that the assessment of all public utilities is at a certain rate. The assessment of all other commercial property is at a certain rate. Assessment of residential property is at a certain rate. And all that came about as the result of this lawsuit. Now, I have to say I was not the only lawyer for the Southern Railway System in that lawsuit. There was a great lawyer from East Tennessee named Clyde Key, who was the real brains behind that case.
But you were counsel of record.
I was counsel of record. They wanted a lawyer in Nashville. They had another lawyer in Nashville, but they hired me as well. Another case that I just had to win, I was hired by 42 trial and appellate judges about 1977. Judges with the same jobs on the appellate courts and on the trial courts were not being paid the same. It was all the result of a statute that had been passed by the legislature, and I won't go into great details, but some of them were limited to increases in their salary at 5% a year. And others had their salaries determined automatically under the then existing statute by the cost of living index, which could be more than 5% a year. So they were being paid unequal amounts. Well, 42 of them got together and hired me to try to do something about it. Judge Allen Cornelius was sort of the lead goat in the case. He determined to be the plaintiff in that case. He was a judge on the Criminal Court of Appeals at that time. Well, the bottom line is that we got that statute declared to be unconstitutional and got their pay equaled. And a couple of those judges wound up on the Supreme Court. One of them was Frank Drewota, one of them was Al Birch, recently retired Court of Appeals Judge Ben Cantrell was one of them. I thought, if I lose that lawsuit, my career is over.
These gentlemen, and I trust that those judges were all men at the time, could have hired any lawyer in the state of Tennessee. Why did they call Doug
Why did they
Fisher?
choose me? I've often wondered. I don't know. I don't know why they chose me.
It's my understanding there was one a humorous anecdote in this, and that is that your lead client, Judge Alan Cornelius, with whom you had to work directly and he had to work with you, a few years earlier had held you in contempt of court for standing up and speaking when he told you to sit down.
That's true. That was about 1961. He was a General Sessions judge at the time, and he was determined to keep order in his court, with which I was very sympathetic. But I was in court one morning, and I had an associate sitting next to me. And he had instructed everybody, sit down and don't say anything. You know, I'm calling the docket. And I followed his instructions, but I scribbled out a note and handed it to an associate who was sitting next to me. Judge Cornelius took offense at that. He said something like, I thought I told you not to talk to each other. And I got up and said, Judge, I wasn't talking to anybody. May I explain? He said, no, you may not explain. Sit down. I said, I am not going to sit down. I'm going to stand up. I'm standing up and I'm leaving this courtroom. Fine me for contempt, if you like. And I walked out of the courtroom and he yelled after me, $10. I walked right down to the clerk's office, paid the $10, and I've got the souvenir receipt for my fine for criminal contempt. But the reason I had to leave was I had a trial that was about to start down at the other end of the hall, and he wouldn't let me tell him about it.
So you were going to be held in contempt by one judge. It was just a question of which
one. It was a
one.
choice of which court is going to hold me in contempt. So I chose the lesser of the two evils, and I immediately forgave Judge Cornelius if he needed forgiving, and we were good friends until he died, and had a very pleasant relationship, and I told him afterwards I was perfectly sympathetic with his desire to bring some order to the zoo that was then the General Sessions Court.
Let's go back to your summary of some of the more significant cases in which you were involved.
Well, the most important plaintiff's case that I was ever involved in, I suppose, was the Waverley Disaster. There was in about 1980 or thereabouts. There was the explosion of a railroad tank car near Waverley, Tennessee, in Waverley, Tennessee. The train had derailed, and as a result of the derailment and later lack of safety precautions, the propane tank had exploded, and it killed some people and injured many people with horrific burns. There were about 40 lawsuits that were filed as a result of that, and they were put together before Judge L. Clure Morton in the United States District Court in Nashville. The lawyers got together and voted on a small group of us, 6 of us, to conduct the lawsuit in behalf of all of them. I was one of the 6, called the Plaintiff's Steering Committee, and we divided up the work. I took the case against the manufacturer of the wheel that failed, fractured, caused the derailment. Other lawyers one took the case against the tank car, another took the case against the railroad, and we had a number of defendants. Over a period of 18 months, all over the country, we took 40,000 pages of depositions in that case. Judge Morton gave us a room in the federal courthouse, and we hired a librarian to keep up with the papers. we examined mountains of documents, and I took, along with other lawyers, a deposition of the engineer who was responsible for the wheel, for the design and manufacture of the wheel that failed. And that deposition took 5 days, 8 hours a day. If you can imagine 5 days of depositions about the design and chemical composition of a railroad wheel and why it failed. But we got the goods. Judge Morton did a masterful job in bringing about a settlement of that case. The settlement was put under seal for several years, I think because Judge Morton did not want people preying on the victims who suddenly had got very large amounts of money. We settled those cases for about $25 million. And that was a very rewarding case in terms of fees.
You were very involved in a decision Judge Morton made about the fees and which lawyers would be compensated. Tell us about that.
Judge Morton hammered on the defense lawyers to try to bring about a settlement, as he should have, and he hammered on the plaintiff's lawyers. On the plaintiff's lawyers, I was a plaintiff's lawyer, of course. We had contracts, typically for a third of any recovery. Well, a third of $25 million has been an awful lot of money. And Judge Morton thought that in order to bring about a settlement, he ought to find some way to reduce that amount significantly. So he proposed that he would, in effect, make those of us on the steering committee rich by paying us a very, very high hourly fee for the work we had done over that 18 months with only nominal compensation to any of the other lawyers because they hadn't done any work, essentially. I pled with Judge Morton not to do that because all the other lawyers would think we'd sold them out. They had contracts for a third. And although we had done all the work, they had valuable claims. So Judge Morton accepted a compromise and just cut the fees in each case, to which we eventually agreed to 20% instead of 33.33%. And got the cases settled. He hammered on both sides. The way he convinced the defendants to settle, I remember very well. He said, he told the lawyers, I'm estimating these cases as complex as they are and as many defendants as there are. It'll take about 18 months to try. He said, once a lawyer takes a seat in my courtroom, he's not going to leave till the case is over. And all you defendants know, you send 2 or 3 lawyers over here, you got them for 18 months on the payroll in my court. He said, the court reporter's fees, you're going to want an overnight copy. I remember I fixed the per page fee. It's going to cost you defendants $7 or $8 million, I can promise you, to even try this case. And then you've got a very big risk for some unprecedented judgments. Well, he had separate meetings, as he was allowed to do under rules of complex litigation, with lawyers for the plaintiffs and lawyers for the defendants. Called us up to Cookville, where he was staying at that time, and spent days with each of us, brought about the settlement. We never knew, we plaintiffs, which defendants paid how much money. The defendants never knew which plaintiffs got how much money. One of our plaintiffs got the largest judgment, which was several $1 million, and another one got another big 7-figure judgment. But to decide which plaintiffs got how much money, we had a system that the lawyer, for example, I had no part in determining the value that the steering committee put on the cases of my plaintiffs.
In other words, those who are represented by your firm individually.
Right. And we'd evaluate each other's cases, and we'd have hearings. The steering committee had hearings, and the plaintiff's lawyers would come in and bring their medical proof, and the committee would meet and propose a value for that case. And after we'd gotten all these proposed values, excusing the individual lawyers from the individual cases, of course, ultimately, we all had to agree on them. That's what we did.
You've been practicing law for, what, 57 years?
54 years.
54 years.
54 plus.
For 45 to 50 of those years, you had one of the most active practices of any lawyer in Tennessee. But in the last few years, you stopped accepting new cases, but you've continued to handle them. How are you winding down, and where do you stand today?
Well, I've got a case in the appellate court system that has got to wind down before I can quit. I've completed nearly everything else I've got. I still go to the office. We've got 21 lawyers now. Younger lawyers doing all the heavy lifting. I get to the office in mid-morning, certainly in time for lunch. And I do some busy work for the law firm. I will be 80 my next birthday. I think it's time to quit.
How has your view of the practice of law changed over these decades?
Well, the most worrisome thing to me about the way that the practice has changed is the jury trial in civil cases is almost a memory. I saw a statistical report of the jury trials in civil cases conducted in the year 2006. 48 civil jury trials for the whole county in the year 2006.
In Davidson County.
In Davidson County. I remember years in which I personally tried at least 48 civil jury cases. I'd often try 2 or 3 of the the commonplace wreck cases and condemnation cases in the space of a week. We had hundreds of jury trials a year. And the appalling thing to me is we've spent nearly $50 million rehabilitating the historic courthouse where our civil jury trials are now held, such as they are. But you can walk through that courthouse from the top to the bottom, and where you used to see throngs of people on each of the floors where the courts are located. I took my old partner Johnny Harwell through on a walkthrough of the newly remodeled courthouse a few days ago in the middle afternoon. We walked on the 6th floor where there are courts, the 5th floor where there are courts, the 4th floor where there are courts. Those are the floors on which the courts are located, and there wasn't a single court that was not locked up or dark. Nobody in any court, nobody on the benches outside, none of the throngs of people that used to be there. What's happened is that we lawyers have priced ourselves out of business on a lot of the routine litigation. We charge too much money. We take too many depositions. We feel that in every case, we need to be so fully prepared that we take depositions and interrogatories, and we send requests for production of documents. And by the time you get to the end of the case, the client has spent so much money on his legal defense that he could have settled the case for less than he's paying the lawyer. So litigation of ordinary cases costs too much money, and it takes too long. Sometimes a case is several years getting concluded. So what's happening now? Serious litigators, volume litigators, the type of people that we represent, they want the case over. They want the case over pretty soon after it's filed. They want to mediate because it's quicker, it's cheaper, and they can get it off the books. And the mediators around town have taken such a load off of the courts that the judges must feel that they are sort of obsolete. It must be a privilege if you're a circuit judge to get a case to try. In that same statistical report in several of the small counties around Davidson County, in the year 2006, there was not a single jury case tried in a civil case. Now, the new criminal courthouse, that's a different story. They've got plenty of business.
What is the solution to the jury trial dilemma?
I believe that there may be no solution. Lawyers aren't going to go around cutting their fees. At least I think not. Lawyers who would like to get some of that business back get a lot of jury trials. They're going to have to find a way to make litigation less expensive. I know one old lawyer who insurance companies loved, not in our firm. They would send him only small cases with limited exposure, but the reason they loved him is he wouldn't prepare for trial. He wouldn't run up all those fees. He'd just go over there and try the case and see how it fell out, sort of like we used to do in those criminal cases. And his fees were modest. He got decent results in most of those cases, impromptu, no depositions, typically, no nothing. Just go over there and try the sucker. If the lawyers ever get that big stream of business back that we used to have, lawyers are going to have to change their ways. Now, we still have a lot of big litigation, but you know, if the case is real important, both sides want to settle, want to mediate. A mediator in my office, one of my lawyers, last 3 years has mediated over 1,400 cases.
What do you see the direction or the future of the legal practice to be?
I believe there will be a great demand for lawyers, unlike the time when I became a lawyer, because our society has gotten so complex, and there's so many regulations and governmental initiatives, and so many new fields of practice that were not there when I started. I mean, there's a lot of the firms now have specialties in intellectual property, specialties in elder care, specialties in all sorts of things, mediations that did not exist years ago. And the volume of claims as well as the volume of merger and acquisition work, real estate work. Everything's gone up. So there'll be a great demand for lawyers. But I think the day of the lawyer who could count on having civil jury trial work like those of us of my generation did, I'm afraid it's gone, and I think it's a great loss. How are you going to value cases for mediation if you haven't tried a few? How are you going to train the young lawyers to be good trial lawyers when they can't get into court? If we lose the jury system for civil cases, it will be a profound loss for the public, for this country. And they've lost it in England. You know, they have juries for criminal cases, but except in, I think, police cases and in defamation cases, they don't have a jury anymore in England.
If your firm were to hire a brand new lawyer today with no experience right out of law school, and if that lawyer were to come to your office and say, Mr. Fisher, I just want to introduce myself. I'm your firm's newest associate, and I know you're the senior partner. Would you give me some guidance on what it will take for me to be a good lawyer?
You know, I wish some of them would come and ask me. I would say that there are some simple things you can do that have nothing to do with the ability necessarily of your legal skills, with your intellectual gifts. So the first thing, it all comes down to common sense and good personal relations. The first thing you do is every bill that comes into you from a vendor, from a court reporter, from an expert witness, from all of the people that you depend on to make your business work, you pay it the day it comes in. You don't dilly-dally and say, well, it's really my client's obligation. You pay that bill. You hired that person. Whether you get it back from the client or not, it's your responsibility. That is sufficiently unusual that that'll get you a lot of notice. The next thing that you do is you return all your telephone calls. You return them on the day you get them, if possible. I've had lawyers call me up at night, and I can't tell you how much this has impressed me. I'm sorry I didn't get to return your call today. And, you know, I ordinarily I say, well, it's not that urgent, but I remember those lawyers. I would say just fall in love with your calendar. These computer calendars now are absolutely wonderful. They're so easy to maneuver and so easy to plan things ahead of time and to set deadlines for yourself without having to do a lot of scribbling. So easy to change things, so easy to look at and see what's ahead. And so many, we've done a great deal of work in defending legal malpractice lawsuits, dozens and dozens of them. And just attention to your calendar. I would say try not to ask for continuances. Do everything that you can very promptly. Be sure in these days of computer work, where your computer can crash at the last minute, be sure you have got your pleadings done before the deadline and you're not faced with some inability to produce the document. Liberally give extensions and continuances to your colleagues unless they're trying to abuse the requests. I used to think, do unto your adversaries as they do unto you, and if they were liberal with me, I'd say I'll be liberal with them. And I now believe you ought to be liberal with them regardless. take the high ground. Don't engage in any kind of ad hominem attack on your adversaries. Do unto your clients as you would have them do unto you. Going back to the billing, think in terms of what your clients need, not in what would be most comfortable for you. And it's the old golden rule. If you learn the names of the clerks, by the way. Learn the names of the clerks in the circuit court clerk's office. Learn the names of the bailiffs. It's incredible how those people can help you have a successful law practice.
With that sage advice from an immensely respected lawyer, I say thank you, Douglas Murray Fisher.
Thank you.